Okay, I think we will get started. I see people are giving greetings in the chat from Cleveland and Portland and from all across the country, and we already have hundreds of people joining us. So thanks everyone for being so on time. My name is Diedrich Asante Muhammad. I'm Chief of Membership Policy and Equity at NCRC, the National Community Reinvestment Coalition. And I will kind of kick off and close this important conversation around CRA and race. Before we get started, I'd like to remind you all that NCRC's Code of Conduct applies to all gatherings, including this one. You can submit your questions at any time through the Q&A button at the bottom of your screen. And for those of you who may be new to NCRC or attending one of our events for the first time, just tell you a brief little summary about NCRC. NCRC, again, the National Community Reinvestment Coalition, is a coalition of community organizations across the country who work to create a more just economy with a specific goal of building wealth for people who have been cut out from opportunities. We focus on the policy and practice of housing, entrepreneurship, banking services, with a mission of addressing historic and ongoing inequities. Now to start getting us a little bit more focused in on our subject today, we're going to be talking about the Community Reinvestment Act and race. Just to give a little context, this October marks the 44th anniversary. This past October marked the 44th anniversary of the Community Reinvestment Act, or CRA. And as the Federal Reserve looks to modernize the law, one thing is clear, that the racial blindfolds of CRA must be removed. The CRA was one of several important pieces of legislation passed in the 1960s and 70s to address racial economic inequalities, all focused on reducing discrimination. But as we can see in our current economic status, none has done enough to affirmatively improve equality. The Community Reinvestment Act, passed in 1977, was designed to go beyond simply preventing discriminatory lending practices. It was written to encourage investment in all communities. But while the law targeted low to moderate income neighborhoods explicitly, it did not explicitly address racial economic inequality. And the results speaks for themselves. Today, more than 40 years since the CRA and more than 50 years since the Fair Housing Act, the Black homeownership rate is just 42%, as low as it was before CRA was implemented. Latino homeownership rate is about 50%, while at the same time, whites have a record high homeownership rate of about 73%. In 2019, the median Black wealth was just $9,000 as compared to Latinos at $14,000 and for whites, $160,000. So we clearly see there's a lot that needs to be done in addressing investment in different communities. And we see that modernizing the CRA to include race-conscious provisions is a critical step that can help address these issues that a race-blind CRA has failed to adequately move. So just a couple more points on where we are in the progress of CRA being modernized and updated. In the fall of this year, the OCC proposed to rescind its rule, weakening the CRA. Final decision is expected in January. The Fed announced possible CRA changes in advance notice of proposed rulemaking late last year. And if the Fed proposal is strengthened, it could represent a united path forward for the three regulators. We expect the Fed proposal in early 2022 after the OCC rescinds its 2020 rule. And to get more into this, and one of the authors of the paper that NCRC co-produced, we will kick off with Glenn Schlachtis, who is a partner at the Relman Colfax law firm. So let's hand it over to Glenn, who's going to give us a presentation of the depth and substance of the paper. We'll then have our own Josh Silver from NCRC respond a bit to that, and then be taking your questions in the Q&A section, and then we'll close out. So thanks everyone again for coming. And Glenn, let me hand it over to you.
All right, thanks so much, Diedrich. And I am going to share my screen to call up a deck that I want to walk through about really about two things. There's it's about the proposal, but that's part 2 of this deck. That's the proposal we've made about how we think CRA should be adjusted to explicitly consider race and how lenders are doing in meeting the needs of communities of color in their assessment areas. The first part is about the legal context, legal considerations that must be accounted for in any proposal for it to survive challenge in the courts. And the first question with respect to the legal context is, well, what's the source of the concern? Why? What legal rules? What's the source of legal limits on how race can be considered by the government in the CRA? And that's the Equal Protection Clause of the Constitution. And that applies to both the states and the federal government. And it comes into play whenever the government is acting on the basis of a racial classification, when it is making decisions about who is going to get what benefit, get whatever from the government, and race is a factor in that decision making. And I'm just going to use race in this discussion, but just to be clear, that includes consideration of ethnicity as well. So when equal protection is implicated because the government is acting is using a racial classification, let's bring that closer to ground. What does that mean? What are the limits? What are the tests that courts will apply to determine if the way government is using race is constitutional? And the test that is used is called strict scrutiny. And that has 2 parts. The first asks, well, why is the government using race in whatever manner it's proposing to do so? Is the reason the government has what the government's advancing, does it count as a, quote, compelling interest, unquote? And the second part of the strict scrutiny test is, well, how is the government going about using race? Is it doing it in a way that is, quote, narrowly tailored, end quote, narrowly tailored to meet that compelling interest? And the next few slides, I will unpack compelling interest and narrowly tailored a little bit. But first, the caveat on the bottom of this slide, which is that strict scrutiny is not triggered when the government is simply collecting information about race, publishing that information, but not making any decisions based on any individuals or any groups' racial characteristics. So the census is the most obvious example of how the government is gathering such information, and the government does not need to satisfy strict scrutiny in order to conduct the census, even apart from it being actually enumerated in the Constitution. The Home Mortgage Disclosure Act, to come closer to home with the CRA, the government could pass the Home Mortgage Disclosure Act and have lenders, require lenders to collect information about the race and ethnicity of applicants and publish that information without satisfying strict scrutiny. So the first part of the test, compelling interest, well, what is a compelling interest? And the short answer maybe sounds too cute, but it really is what it comes down to is if the Supreme Court says an interest is a compelling interest, then it's a compelling interest. Fortunately, in the lending space, the government has, the courts, Supreme Court and lower courts, have made clear that remedying the continuing present day effects of past discrimination and present discrimination is a compelling interest for the government to act on and use race in making decisions. So to support the explicit consider of race in CRA evaluations, we do not need to come up with a new compelling interest, and we don't need to convince the courts, more importantly, that something is a compelling interest that it has not already done, given how plainly the lending markets have been and continue to be affected by discrimination, historical and ongoing. The court say that this interest in remedying continuing effects of past and present discrimination is especially strong when the government has been a participant in that discrimination, as it certainly has been historically in the lending markets, and to avoid being a passive participant in markets that have been and continue to be very much impacted by discrimination. So to put it another way, the government has a compelling interest in not putting its funds into a market that is affected by discrimination, such that its funds, government funds, would really further divides that are based on discrimination. So as we'll talk about a little bit more later, lending really fits well with this existing case law about compelling interest. A little bit more about compelling interests. If you're in court, you need to produce substantial evidence that this problem of continuing impact of discrimination is real. The government cannot defend the use of race by simply saying, we believe there is this problem that needs to be addressed. The government has to present actual evidence, quote unquote, substantial evidence, that this is addressing this there's a real need for a race conscious approach to addressing the continuing impact of discrimination. And that has to get fairly specific to just what the government is trying to do, or I should say to just the manner in which the government is using race. So, government cannot say, well, we're going to use race in CRA because there's lots of evidence of general discrimination in society, or even across the banking world generally. It really has to get fairly specific. So evidence of discrimination affecting, say, the small business lending market is not really an adequate justification to be race conscious in the residential mortgage lending market. So this evidence really has to be, pretty pinned to the type of program in which the government is aiming to consider race explicitly. Next, a little bit more about the narrow tailoring prong of the strict scrutiny test. And at a high level, the reason courts give for having this narrow tailoring program, and not just saying that once you've established a compelling interest in using race, you can use it in any way you want. The idea is that race should be used in really the most limited way that the government can, commensurate with the problem that it is trying to address, so that this exception to the Equal Protection Clause that allows the government to consider race in decision making when there's a compelling interest should be, should only go as far as it needs to in order to comport with equal protection. So that's at a high level for narrow tailoring. To bring it closer to ground, There are several specific questions that courts typically ask in determining whether government use of race is narrowly tailored. And after this, I'll have a slide unpacking each one a little bit. And these are somewhat overlapping depending upon the circumstances. The first one is the government cannot jump straight to using a race-conscious approach to trying to solve a problem. It must show that it has first tried or at least considered race-neutral approaches to the problem of discrimination before it is allowed to use a race-conscious approach. Second, is the program over or under inclusive? Courts want to be satisfied that more or less the right groups of people are getting the benefit of consideration of race, and that groups that should fairly be included are not left out of some sort of affirmative action program. Flexibility in the program. I'll save that one for the slide on flexibility. That will illuminate it a little better instead of describing it more abstractly. The fourth one is the program's duration limited. Probably the easiest one, because you can build into a program that it will be revisited 2, 3, 4 years down the road, whatever the case may be, to determine whether the need is still there. And then the burden on third parties, people who, groups who do not obtain the benefit of the government's consideration of race, typically non-Hispanic whites in most affirmative action programs. Courts want to be satisfied that the burden is not too great on those folks. So race neutral solutions, and what do the courts say about that piece of the narrow tailoring requirement? The first is they want to see really evidence of genuine consideration of race neutral solutions, not simply lip service. So you really need to be prepared to show that this is not just the first approach the government has jumped to. And what is genuine consideration exactly? That's going to differ from court to court, but it is an opportunity. This piece is an opportunity for courts to scrutinize the government's use of race fairly closely. At the same time, though, Supreme Court precedent is clear that the government need not have considered or tried every single possibility under the sun, because as you can imagine, that can just go on forever, right? One can always think creatively about a different possible race-neutral approach to addressing a problem that stems from discrimination. So the doctrine is clear that you don't need to consider every possibility, but what we have seen, especially this year, decisions earlier this year in certain programs, is courts are willing to, think fairly hard, fairly deeply about some possibilities. And so you certainly, before the government adopts a race-conscious program, you really do want to make sure that reasonable sounding approaches have been considered. So this again, satisfying this prong though does fit well with lending for reasons that Diedrich was talking about at the outset. We've had CRA around for over 40 years. We've had many other income-focused programs that parallel the CRA's historic focus on income through looking at lending to low and moderate income people and communities. And yet, these rather exceptional racial gaps continue. with respect to economic opportunity and opportunities for credit. So I think there's a very strong case to be made that the race neutral solution piece of narrow tailoring is satisfied with respect to lending. Over and under inclusiveness gets at who's eligible and who isn't eligible, and also where. The geographic piece is important because discrimination will play out differently depending upon what part of the country you may be in. It's not going to be exactly the same in Washington, D.C. as it is in, say, North Dakota or any other part of the country, where the evidence shows discrimination is distorting the market, and as to what particular groups, Black, Hispanic, et cetera, is going to differ. And courts want to see that attention has been paid to those differences in crafting a program, and program rules about who benefits and where, which is to say where race is used and where it is not. Flexibility, the leading rule on flexibility is quotas are anathema. Quotas should not be used. Goals are appropriate. Goals based on race, but not quotas. Secondly, tailor them to local circumstances, and that gets to that certainly overlaps with the over and under inclusiveness that I was just talking about. And how do you figure out what a goal should be analytically? Well, the courts want them to be based on the gap left by discrimination. So if let's say one could show statistically that in a particular metropolitan statistical area, there are, let's say, 5,000 residential mortgage loans being made to people of color in a year. Well, if you could show that absent discrimination, there would be 15,000, then your goal should be to get that number from 5,000 to 15,000, and you should construct a program around that type of goal. The next piece, very important, a good faith effort to achieve a goal should excuse an entity's failure to do so. So this is like a safety valve. So it's not just automatic. If an entity has made a real genuine effort but has come up short of its goal, it should not be penalized for in that circumstance. Race as a supplement to, not a replacement for, other factors. So in the CRA context, what does that mean most plainly? Race should not be brought in a manner that displaces consideration of LMI, low and moderate income, but it really should work hand in hand with other important factors. And then last, and this is really the underlying reason why quotas are anathema, is that race should not be used by the government in decision-making in a purely mechanical way. There can be mathematical considerations, absolutely, but at the end of the day, decision-making that involves race should be qualitative. Burden on third parties. Courts say some is okay. Just what that means is abundantly unclear. But one important way of dealing with that, depending upon the program, can be to allocate a benefit, just a portion of a benefit, in a race-conscious manner, and not with the rest of it. And we see that approach in the homeowner assistance funding that was passed as part of stimulus legislation this past year and will start rolling out in 2022. Limited duration, as I said, really not a hard one to satisfy, have a sunset date or a date certain when the program will be assessed to see if there's still continuing need. So the proposal that we've made in light of these legal rules, legal limits about how race can be considered, has several parts. The first set of proposals is really it's informational, and this actually I don't think does implicate strict scrutiny. Because this is about gathering and publishing information about race in assessment areas and lending in assessment areas. So that means information about race of individuals in a bank's assessment area, race with respect to neighborhoods, namely neighborhoods that are majority people of color or disproportionately people of color, benchmarks about that are based on how the overall lending market is performing collectively. So what percent of the bank's loans are going to let's say what percent of the overall market loans are going to people of color, and what percent are going into neighborhoods of color. And that's calculated based on mortgage, based on consumer loans, based on small business, and based on small farm loans. So all these different categories of that the CRA pays attention to. We have benchmarks calculated individually, see how the market overall is performing, which provides a basis for comparison to an individual bank under examination. And so that's the lending activity, but it's also with respect to retail service. It's where are the branches located? And then it's also where is the community development financing going with respect to people of color in a given assessment area. And all of these metrics and benchmarks that we have proposed have analogs with the Fed's pending proposal with respect to LMI. So this is we've designed this to really take what the Fed is saying should be collected and published for LMI and have racial analogs for each piece to get a lot more information out there about the so-called performance context. Now, another part of our proposal, this gets at the under and over inclusive concern. We're calling for a government study to identify where past and present discrimination is currently diminishing access to credit. So that means where geographically, it means which specific racial groups, right? Because the answer is not going to be the exact same thing for Blacks, for Hispanics, for Asian Americans, et cetera, in every single assessment area, every single MSA in the country. And then with respect to which product level, because again, this need needs to be justified. This need to consider race needs to be justified at a fairly close granular level. So a study that'll look at where and as to whom access to credit is diminished with respect to mortgage, small business, consumer, and small farm. And I know Josh will talk a little bit later, a little bit more about the type of study we're calling for. And then once you've identified, where as to who and as to which products, how should the consideration of race be incorporated into evaluations? So we've made a primary proposal and a secondary proposal with respect to retail lending. Our preferred option with respect to retail lending And again, this mirrors what the Fed has proposed with respect to LMI. But our proposal here is for major product lines to create a threshold level of lending that a bank has to achieve to be given a satisfactory rating on the retail lending subtest. And those threshold level, as with the proposal for LMI, would be based on those market benchmarks. And to comport with the equal protection requirements of the narrow tailoring piece, bank making a good faith effort to reach the threshold level but coming up short would still qualify for the satisfactory rating. So a good faith effort might be affirmative marketing, it might be adoption of special purpose credit programs, it might be designing products that are aiming to serve people of color in its assessment area. But whatever those efforts may be, the good faith effort needs to be there as a safety valve. Second, performance ranges for each of the different potential ratings that a bank could get on the retail lending subtest. And so, not just have a threshold for a satisfactory, but have ranges that would generate a recommended rating for the test. And you would have performance ratings for each type of retail lending. Now, if there isn't an appetite for that, our second option would be to have aspirational goals. And those goals would be based on the benchmarks as well. And then an examiner could consider as a plus factor a bank's success in meeting or exceeding the aspirational goal, again, for each of its major product lines. And then the same type of proposal as that secondary option with respect to retail services and community development financing. The Fed has proposed a number of benchmarks in this space as well for LMI, and we have proposed parallel ones based on race of individuals in an assessment area and race of neighborhoods in an assessment area, and goals for having branches present, goals for getting that community development financing into neighborhoods of color, and achieving them, exceeding them, again, something that an examiner could consider as a plus factor. Last, a few other pieces in our proposal. One is to enhance the regulator's understanding of how race is factoring in to lending and opportunities for lending across the assessment areas that they're examining. And to do that, we've proposed dedicating research positions and for the regulators to work together to systematically go deeper on understanding this performance context and how race comes into play. Next, right now, as the CRA stands, a lender is not permitted to arbitrarily exclude a LMI neighborhood from its assessment area, but the same does not hold for neighborhoods of color. And so we propose to add that and that examiners should look for that in the course of conducting CRA exams. Third, racial demographics. Well, I'll back up a moment. Right now, there's a distinction between assessment areas that get a full scope review and assessment areas that get a limited scope review. That distinction is proposed to go away, but if it is maintained, right now, racial demographics and lending to communities of color is not considered in which assessment areas are selected for full scope review. And we propose that that be added to the list of considerations. Strategic plans, not many banks do this. I think it's about 5%, but a bank can propose a strategic plan for how it is going to go about meeting the credit needs of its entire community. And then when it's examined under the CRA, it's examined against how well it has achieved what is set out to achieve in the strategic plan. And we propose that in that circumstance, a bank be required to affirmatively go out and seek input from groups that serve communities of color as it formulates its strategic plan. And then last, I've referenced this a few times, but the information that is gathered, the statistics, the metrics, the benchmarks, including that in the public portion of the written CRA exam. And with that, I will stop sharing and give it to Josh.
All right, Glenn, thank you. Yeah, and we will send it over to Josh. If people have any questions or comments, they can start putting it into the chat, and we'll address it after Josh responds for a few minutes to Glenn's presentation. So thanks again, Glenn. Go ahead, Josh.
Good afternoon, and thank you so much for attending this webinar. Well attended. I'm going to own up to a mistake because I gave Diedrich a slide and a few days ago, and the slide said OCC to decide on rescission of its 2020 final CRA rule expected in January. Well, none of us knew it actually happened yesterday. So the 2020 CRA proposal that was finalized by the OCC is now rescinded. Many stakeholders did not think this was a good idea. And just real brief, we think this paves the way for the three agencies, the FDIC, the Federal Reserve Board, and the OCC, to work together on an interagency rule. And we are expecting a proposed interagency rule, hopefully early 2022. So this is one very important reason we're doing this seminar. I'm going to share my screen, and I am going to pick a slide, and I'm going to start the slideshow. Sorry, I need to scroll. I didn't realize I was going to go back to the beginning. Okay, so I wanted to provide some context that before the last major regulatory change to CRA, which occurred in 1995, that's why we need an update, CRA exams did consider lending to people of color. And there was actually assessment factors. They were named after letters of the alphabet. I don't know why. But there was a factor D, and the factor D was called impediments to credit. CRA examiners determined whether the bank had any practices that discouraged applicants for its special credit programs designed to help it meet its CRA obligations. Actually, Glenn made a brief reference to special credit purpose programs, and we actually hope that they are used more now that HUD has blessed it most recently. But just to give you an example of how Factor D was implemented, look at the old Signet Bank exam of 1996. Actually, this exam was probably done right around the time of the last CRA reform. But it says, and I'll just read, for the bank, the percentage of applications from minorities in the Baltimore metropolitan area continues to exceed both the representation in the population and the percentage of lending to minorities depicted in the aggregate HMDA data. Aggregate HMDA data just means lending by the bank's peers. And usually that's all other lenders in the market. So that is a community benchmark comparing the performance of the bank to the community, the percentage of the population as people of color, and comparing it to the industry benchmark, the lending institutions, the peer lending institutions. We would actually like to see also the percent of loans compared as well as the percent of applications. But this actually happened in CRA exams before the 1995 reform. Massachusetts, there are some states in the country that have CRA, and Massachusetts is one of them. And I did a report over the summer looking at Massachusetts CRA exams for independent mortgage companies, which are actually very similar to Massachusetts CRA exams for banks. And they have an analysis similar to what I just showed for Signet Bank. So it has happened before. We think it can happen again. What this slide does is it sort of tries to unpack one of the major recommendations that Glenn just talked about, an interagency study to identify metropolitan areas or rural counties experiencing ongoing discrimination or statistically significant large lending disparities for specific racial and ethnic groups. And some people might say, oh, that's daunting. I want to tell you that actually over the summer, this was very impressive. There were two journalists, Emmanuel Martinez and Lauren Kirchner, that basically did this. And if two journalists, it's not easy, but it's feasible. If two journalists can do this, we certainly think that the agencies working together can do this. They used econometrics. They used a regression model of 17 variables. I won't go into the methodology in detail. We don't have enough time for that. But they found that 91 metropolitan areas had statistically significant findings where people of color applicants were between 20% and 230% more likely to be denied than similarly situated whites. So these could be Glenn's metropolitan areas where there is significant evidence, narrowly tailored, significant evidence of ongoing discrimination or problems, and that we should have performance measures on CRA exams that look at lending to people of color. Let me outline a two-pronged approach that I've been mulling in my head, and we think that NCRC will propose a version of this. For looking at performance to people of color, use the approach that Glenn outlined. Identify the areas where there's significant disparities and add performance measures that look at lending and services to people of color. For places, for neighborhoods, I would add an additional approach. It's kind of a proxy approach, but in a way, it's very consistent with the underlying purpose of CRA, combating redlining. And redlining basically means, in a nutshell, no service or underservice. That there are areas that are relatively underserved by banks. And how do you determine that? Well, there's a simple metric. The number of loans on a per capita basis. You could do home loans on a per capita basis, which would be per owner occupied housing unit in the census tract. Small business lending compared to how many small businesses there are in the census tract. So we identified the quintile of census tracts across the country. That means 20% of the census tracts that had the lowest levels of lending on a per capita basis. Underservice, purpose of CRA. On average, these census tracts, 57% of the residents were people of color. So in this approach, you don't even have to go through compelling, making sure it passes strict scrutiny, because it's not explicitly serving communities of color or people of color. But in my mind, it achieves the same result. So underserved tracts could be a category on CRA exams, say on the lending test, the service test, the community development test, tomorrow, without having to go on every single CRA exam, without having to do your interagency fair lending review. So I would say interagency fair lending review to identify areas where you have people of color performance measures on CRA exams. And then for places, consider underserved tracts as a category in your subtests. And with that, I am going to stop sharing and turn it back over to Dietrich. Thank you.
No, Thank you, Josh, and thank you in particular for highlighting to groups, what they can be doing in their communities around this type of issue. I would like to discuss that a little bit more in the little time we have left, but there's one semi-technical question that I'll put forward that I saw in the chat. And the question was, do you see the pending Supreme Court cases, students for fair admissions versus Harvard, impacting our ability to move CRA and race forward, at least under these theories? So I'll see if Glenn or Josh wants to respond to that. Oh, and I will just note that it's been mentioned in the chat that the slides and the recording will be sent out to all registrants in the future. People have been asking about the slides. But go ahead, Josh, Glenn.
So a lot of what we know about what is a compelling interest and what's narrow tailoring does come from the Supreme Court last major decision with respect to higher education and affirmative action. That was the Grutter case, or pair of cases involving University of Michigan admissions and University of Michigan Law School admissions. And there's a lot of, I think, good stuff in there that helps us with making the case for or demonstrating that the use of race with respect to CRA is constitutional. So the Supreme Court taking up another affirmative action case certainly has some potential to adjust the existing doctrine. At the same time, I think, a lot of that has become what we saw in Grutter and then what we've seen since, and what we've seen from the Supreme Court in minority contracting cases, which is another important context. It's become, the overall rules have become fairly embedded, I think. So if this has an effect, I don't think it's going to change the rule book. Does it give us some additional guidance that may or may not be welcome on how to apply a particular factor? That's a possibility, and we do have to look for that. But I think that would be more at the margins. I don't think it's going to change the rule book here.
Sorry, I was on mute. Josh, you have anything you want to add to that?
Well, I'm going to leave it to the legal expert about the Supreme Court case. Actually, Wilson Good Jr., glad you could be with us. How far can you go in defining good faith efforts? I think that's a good question.
That is a good question. And, there's a significant piece of this that is in the eye of the beholder in any given case, and the beholder is the judge in any given case. But the precedent saying that this does not have to be comprehensive, you do not have to have looked at every single possibility. There's good language on that from the Supreme Court. That is not just from the lower federal courts. So I think by and large, really the best interpretation is not, not ends of the earth, nothing approaching to the ends of the earth, but it's got to be genuine. And, fortunately in the CRA context, there is so much effort, so much evidence of decades worth of effort to overcome the problem of discrimination in lending, and so much evidence that it hasn't been enough.
I see one more question. I think we have time for, I guess it's two questions put in the Q&A box. It says, first, you might have talked about this a little bit, but first, can you say a word about how you think the CRA or other statute allows for consideration of race in the CRA context? And then second, can you speak to the interaction between CRA and fair lending exams?
So on the first, Maybe I'll take the first, and Josh, maybe you want to take the second. But yeah, I take the question as, does the statute allow, in its current form, does the statute allow regulators to implement consideration of race in the way of posing? I think it definitely does. I do not think statutory amendment is required to do what we're proposing. And there are a few reasons why I think it does. One is, well, there's certainly nothing on the face of the CRA that says you can't. Second, what the statute, the touchstone in the statute is that, financial institutions need to serve the entire community. And it seems very straightforward to me to include neighborhoods of color in the entire community. And I don't think one is that's right down the middle to me. The statute does say including LMI, low and moderate income, but by no means does it say, that is the only, say, subset example. So I think it very much fits within the meaning of that phrasing in the statute. Third, you've already got a couple of ways in which the CRA does call for explicit consideration of race. It's just much narrower than what we're proposing, but it has to do with looking at and giving CRA credit to financial institutions that are working with helping minority depository institutions. So it's already there to a degree, and this is not a change in kind. And then last, the legislative history. Really, I think, Diedrich, you were referring to this a little bit at the outset. It is quite clear that a key purpose of the Community Reinvestment Act from the start was to address problems of racial discrimination in lending and redlining. So I think there's a very, very strong argument, a much sounder argument, that statutory amendment is not required than any argument that it would be.
And just real brief to answer the second part of Debbie's question, thanks for asking that. The interaction between fair lending exams and CRA exams, which are supposed to happen concurrently. The Fair Lending Review makes sure that the bank is not discriminating or engaging in other illegal behavior. So if the Fair Lending Review finds that the bank has been engaging in discrimination, if the discrimination is widespread, not confined to like one bad employee, for example, if it's widespread, a rating, hopefully, now in the view of advocates, should be lowered. The examiner has a discretion whether to lower the rating or not. In contrast, if you had race on CRA exams, assuming a bank has passed its Fair Lending Review, then you go to see how well they are doing in terms of lending to race, lending to people of color, branching in bank services to people of color and communities of color, and that's different. You can still pass your CRA exam, but like get a low satisfactory, for example. Whether adding this to CRA would in any way weaken enforcement of the fair lending laws, well, none of us certainly hope, none of us want that to happen. And part of the tasks of advocates over the years is to also hold the regulators accountable. And if we see sloppy CRA exams or sloppy fair lending reviews, we raise this to the attention of the regulators, and if needed, you raise it to the attention of the public. But if you create a framework that you think is more rigorous, that at least creates a potential for addressing the wealth divide that Diedrich has talked about. And lastly, real quick, Buzz, yes, I think you can put race data on like all the assessment areas in the CRA exam, and still, if you decide you're only going to use race performance measures in certain assessment areas, I think that's permissible. I think that I don't think I misspoke, Glenn. And I'm done. And thank you so much. I guess we give it back to Diedrich.
Yeah, no, Glenn.
Josh, real quick.
Oh, go ahead, Glenn.
I see I answered the wrong question before from the chat. I answered about sort of good faith consideration, not good faith efforts to meet a goal. And I think the answer is, yes, you can get fairly specific in rules about what a good faith effort means. Just leave space for it to ultimately be a qualitative determination.
Great. Well, thank you, Glenn and Josh, for this conversation. You can obviously get access to the paper to learn more, check out the NCRC websites to hear more about our advocacy on this. Before we close out, or as we're closing out, just want to highlight membership options for both organizations and individuals to join NCRC. Nonprofits, local and state government agencies, and educational institutions are eligible for organizational membership with dues based on their annual budget size. Membership value includes members-only meetings, customized research, discounts to the Just Economy Conference. Individuals also can join and they can support through the Just Economy Club on a monthly or annual one-time basis. If you want more information, any of the membership information, reach out to our membership team. Membership@ncrc.org is their email. Thank you again. It's great to see hundreds of people coming out at this time to hear this type of discussion, this type of analysis, and look forward to further conversations with you all. So thanks again.